SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. I am Dr. Ashutosh Acharya, Senior Assistant Professor from Law Center 2, Faculty of Law, University of Delhi. So far, we have already discussed about the historical background, existence of laws, rules and regulation pertaining to sea, the basic relationship between the state, ships sailing through sea and laws that are applicable on sea. All the presidency courts that were having jurisdiction to try Admiralty matters, the same jurisdiction gets transferred to the different high courts situated in different states now. The boundaries that we see today were not in existence as far as the British time period is concerned. So, when India received freedom and with the advent or with the passage of time, we see that different regional areas were divided into different states, Odisha, Bengal, or for that matter Andhra Pradesh, and then we see Tamil Nadu, Kerala, Goa, Maharashtra, Gujarat, all of them having coastline. And when ship enters into their coastline, comes into their port or passes through their port or loads or unloads at the harbors or ports of these coastal states, then if any wrongful act is identified, then these high courts or relevant high courts can have jurisdiction with respect to that particular wrongful act whenever a claim is brought against that particular wrongful act. But then there was no law existing to provide jurisdiction to the high court as far as Admiralty matters were concerned. So, high courts were to an extent devoid of Admiralty jurisdiction, but post 1993 through M.V. Elizabeth case, Supreme Court cleared the legal position and allowed Admiralty matters to be tried before the high courts and expanded the scope of Admiralty jurisdiction in India. The question that high courts whether having jurisdiction with respect to Admiralty matters or not was clarified through this case. Attempts were then made further to actually bring a codification, identify the claims, specify the jurisdiction as far as Admiralty matters were concerned. In today's class, we will talk about Admiralty Act specifically. What does the Admiralty Act say? What is the scope of Admiralty Act? What are the claims that it has identified? And what is the jurisdiction? And to what extent jurisdiction can be extended, whether it extends and recognizes the traditional concepts of action in rem, maritime, lien and action in personam also? Such are the questions that we will see has been answered in this act. And yes, we do see that all of these customary practices with respect to claims and jurisdictions have also been recognized under the Admiralty Act of 2017. So, friends, today's lecture is on Admiralty claims under Admiralty Act 2017. Now, if you look at the scope of the act, you will see that the Admiralty Act 2017 applies to all kinds of vessels as per the definition of the term vessel belonging to any place of residence or domicile of the owner. Now, here if you look at the understanding of the word vessel, we will see that a particular ship that is mechanically propelled or a vessel that is mechanically propelled will fall within the domain of the term vessel, and the Admiralty Act will apply on the vessel which is belonging to any place of residence or domicile of the owner. However, it excludes a vessel defined under section 2 clause 1 subclause A of the Inland Vessels Act 1917, or a vessel under construction that has not been launched unless it is notified by the central government to be a vessel for the purposes of this act. So, what does this imply? This implies two things. First of all, that any vessel that is travelling through inland waters is governed by a separate law, Inland Vessels Act 1917. So, that has been excluded as far as Admiralty Act is concerned. Secondly, it includes a vessel under construction that has not been launched. So, a vessel can be considered to be launched only when the central government notifies that a particular vessel is now allowed to be sailing. Now, when does the central government notifies? A vessel can only sail if it fulfills the requirements notified by central government. What are the requirements? For example, that any vessel that has been constructed has to obtain certain certificate, fitness certificate for example, whether it is in a sailing condition or not in a sailing condition, whether it qualifies to be a vessel as far as all construction requirements are concerned or does not qualify to be a vessel as far as construction requirements are concerned. So, in order to take care of the safety and security concerns as far as sailing of vessels are concerned, the central government will notify through providing certain certificates through its constituent bodies such as surveyors, who will also provide a certificate after surveying the necessary equipments of the ship or the vessel, such as the certificate providers under the relevant act and by the relevant authority mentioned under Merchant Shipping Act, wherein the procedure to obtain certificate has been laid out. The central government's notification has also been identified and mentioned under Merchant Shipping Act. So, taking from help from Merchant Shipping Act, we can easily deduce as far as this act is concerned that once central government notifies and gives permission to a particular vessel to sail after complying all the necessary requirements and become a legal navigable vessel, only then we can say that particular legal navigable vessel has qualified to be a vessel as far as Admiralty Act's application or jurisdiction is concerned. So, the scope of the act covers this particular aspect, wherein a vessel under construction that has not been launched unless it is notified by the central government to be a vessel for the purposes of this act. It further excludes warship, naval auxiliary or other vessel owned or operated by the central or a state government and used for any non-commercial purpose, and shall also not apply to foreign vessel which is used for any non-commercial purpose as may be notified by the central government. So, if there is a warship or a naval auxiliary or certain non-commercial vessel which is owned by the central government itself, then it need not follow that particular requirement and also will not fall within the domain of Admiralty Act. So, that has also been exempted as it directly falls under the domain of or authority of central government. Now, Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017. Now, friends, as it in bracket says jurisdiction and settlement of maritime claims, with this we can easily deduce that it deals with two aspects. Firstly, it deals with jurisdiction, and secondly with respect to maritime claims. It also deals with the method through which settlement can be made by approaching to court, how court can allow the settlement of maritime claims and how court will have relevant jurisdiction. Therefore, Admiralty jurisdiction has been defined under section 2 clause A of the act, wherein it means the jurisdiction exercisable by a high court under section 3 in respect of maritime claims is specified under this act. I repeat, the jurisdiction exercisable by a high court under section 3 in respect of maritime claims specified under this act, and section 3 says, subject to the provisions of section 4 and 5, the jurisdiction in respect of all maritime claims under this act shall vest in the respective high courts. So, therefore, all the high courts have been given the jurisdiction to try matters pertaining to maritime claims and be exercisable over the waters up to and including the territorial waters of their respective jurisdictions in accordance with the provisions contained in this act. So, we see that if a claim is brought before Madras High Court, then we can say that territorial jurisdiction wherever it extends from the state of Tamil Nadu up to that particular limit, that will be 12 nautical miles for as far as application is concerned. So, within 12 nautical miles extending from the low water mark of the Tamil Nadu state's coastal line, if any wrongful act happens which is identified or which can be categorized or which can be identified to have been categorized under maritime claims mentioned under Admiralty Act, if any wrongful act happens or if any claim comes into being, then High Court of Madras can have jurisdiction as far as any claim cropping up in that particular area is concerned. If any action is brought before the Madras High Court just because a ship has entered into that particular region. For example, if you remember when we were discussing MV Elizabeth case, we know that wrongful act happened in Goa, but the case was brought in Visakhapatnam because ship moved from here to here. So, since the ship was still within the same national boundary and it shifted from one High Court administration to another High Court administration and comes within the territorial waters of Andhra Pradesh, that is of India of course, but the jurisdiction of the High Court of Andhra Pradesh getting applicable as far as this region is concerned. The High Court of Andhra Pradesh can have jurisdiction because of the same national characteristic features, because High Courts of both the states fall within the same national boundary, and therefore, in general the concerned High Court can have jurisdiction, but at the same time this High Court can enforce the wrongful claim that has happened over the other part of the country. So, therefore, we see that as far as the jurisdiction of the High Court is concerned, all High Courts have the jurisdiction as far as maritime claims are concerned, provided that the central government may by notification extend the jurisdiction of the High Court up to the limit as defined in section 2 of the Territorial Waters, Continental Shelf, Exclusive Economic Zone and other Maritime Zones Act 1976. Now, friends, apart from the jurisdictional section which provides for jurisdiction to the High Court for all types of maritime claims in the country, in section 4 now we will see that what are the different types of maritime claims for which Admiralty jurisdiction can be exercised, or in other words, what are the claims that can be brought before the court by parties, either in the form of action in rem or in the form of action in personam, that is against the whole world or against one particular person. When action in rem is brought into being, it is not brought against the person, it is brought against the res. Res means here property, and in maritime matters it would largely mean the vessel or the ship itself. So, if a case is to be brought against the ship, it will be an action in rem and not against the person. It may shift or transfer into person once the owner appears before the court or admits the jurisdiction of the court. Only in that scenario it may be shifted from action in rem to action in personam. However, it is a peculiar feature of the maritime law or Admiralty law that a suit can be filed against the ship, as a ship through legal fiction or for the purposes of legal application, a ship is considered to be a legal personality. A suit can be brought against the ship itself. Therefore, section 4A and B and up to 4A to clause W, we will see various types of maritime claims coming into being. And what are these different types of maritime claims? Let us discuss, friends, one by one. Section 4A deals with dispute regarding the possession or ownership of a vessel or the owner. So, this is first of the kind of dispute, that if there is any dispute with respect to possession of the vessel, ownership of the vessel, especially in scenarios where there are multiple owners and the possession if is with the master or is with the majority of the owners or one of the owner, or if the minority of the owners are having the possession of the ship, how to settle those disputes. So, the dispute pertaining to possession or ownership of the vessel or the owner, we can institute or the claimant can institute a claim pertaining to this particular dispute. So, an action in rem may be instituted for any claim related to possession or ownership. So, when we say that an action in rem can be instituted, that means a suit can be filed against the ship itself with respect to its ownership or with respect to the possession of the ship, if the possession or the ownership is in the wrongful hands as far as the claim is concerned. The nature of remedy is quintessential to the characteristic feature of Admiralty transaction, wherein irrespective of the registration of the ship or domicile of the owner, a possession of the ship can be handed over to the rightful owner from a wrongdoer. The Admiralty jurisdiction today extends to not only legal claim, but also covers equitable claim over the ship. Earlier, the practice of the court was to not disturb the possession, and the claimant had to establish a clear case for changing the status of possession. In situations especially where master of the ship, when we say master of the ship, we mean here the captain of the ship or the person who is in charge of the ship, who takes all the important and necessary decisions as far as the ship is concerned with respect to sailing, boarding, harboring, etc. So, in situation where master of the ship is also one of the proprietors of the ship, then in such scenarios it becomes difficult to dispossess the master of the ship. Certainly, if the master is the proprietor also, it certainly would become difficult to dispossess the master from the ship, and therefore, this requires then some special reason, that is to induce the court to interpose. However, if majority of the owners of the ship agree to remove the master, even if the master is the proprietor, then he has to be removed. Such claims generally arise in cases of demised charter. A demised charter exists in comparison to voyage charter or time charter. Here charter would mean giving away the ship on lease or on rent, you can say, wherein for if the agreement is of voyage charter, then the ship is given on lease for a particular voyage, that is from point A to point B to point A, or from point A to B to C to D, and then coming back to A. If it is time charter, it may be for a year, for 2 years, or for 5 years, whatever years the agreement says so. And then if it is for demised charter, then it is given on lease, irrespective of the time period, maybe as far as the ship's lease is concerned, or irrespective of the voyage, it may be attached also. But then when demised charter is given, complete ship is handed over without the crew and other kinds of the attachments as far as the ship is concerned. The ship is completely handed over to the person who is chartering the ship. Therefore, such claims generally arise in cases of demised charter, where the owner by right of withdrawal is entitled to possession of a ship, and in order to do so may seek Admiralty action in rem for arrest and possession of ship. So, once action in rem has been instituted, court has given the order to bring the ship in its jurisdiction, then it will be the authority of the court to arrest that particular ship, and once the ship is arrested, the rights of the claimant can be secured. So, such is the procedural action that can be taken into account. Once an action in rem has been instituted, then a kind of charge is created over the ship, and ship cannot be transferred further, or the possession cannot be transferred further without settling this particular claim that has been brought before a particular high court by the claimant. Under section 5 of Admiralty Act 2017, an action in rem can be instituted to a claim related to ownership or possession of the vessel. Based on this claim, proceedings for an arrest of the vessel can also be instituted before an appropriate high court. This is done primarily to ensure security of the maritime claim brought before the court. Now, Admiralty Act 2017 section 5 clause 1 says, the high court may order arrest of any vessel. Now, friends, as I have already told you that Admiralty law has a peculiar feature. Arrest is generally done with respect to persons, and those natural persons are also categorized to be legal personalities, as they have certain rights and duties, and the person can sue and be sued. That is the essential characteristic feature as far as legal personality is concerned. But that legal personality has also been endowed upon the ship. So, the ship can be arrested in order to secure the rights of the individual. Therefore, the High Court may order arrest of any vessel which is within its jurisdiction for the purpose of providing security against a maritime claim, which is the subject of an Admiralty proceeding, where the court has reason to believe that the claim relates to the ownership or possession of the vessel. It may be for any other claim also, where for those claims action in rem could be brought, and we will look at those claims as well in the upcoming slides. In addition to an action in rem, an action in personam can also be instituted if the presence of the defendant can be ensured before the court. So, if the person can be produced, then an action in personam can be filed. In that case, a ship might not be arrested also. Therefore, if the presence of the defendant can be ensured before the court in order to furnish the security, in which case the ship can be set free. So, if certain amount as a matter of security is deposited, the ship can be set free, or you can say bailed out. An action in rem in such cases can be converted to action in personam. So, once a ship has been arrested and if the owner shows up, the ship can be set free once security has been deposited by the owner of the ship. And therefore, an action in rem in such cases can be converted to action in personam once the defendant furnishes security and the case is now instituted in the name of the person against whom a maritime claim has been made. Admiralty Act 2017 section 6 says the High Court may exercise Admiralty jurisdiction by action in personam in respect of any maritime claim referred to in clauses A to clauses W of subsection 1 of section 4. Now, let us discuss one by one, apart from possession and ownership's claim, what are the other claims which can, for which jurisdiction by the High Court can be exercised, or a claim can be brought under the Admiralty jurisdiction of the High Court. So, the second one would be co-ownership of a vessel, wherein section 4 clause 1 subclause B says dispute between the co-owners of a vessel as to the employment or earnings of the vessel. Under A subclause A we talked about possession and ownership, under subclause B we are talking about dispute between the co-owners of the vessel as to the employment or earnings of the vessel. Where there is a dispute between co-owners, the court may order for accounts or for security equivalent to the amount possessed by the co-owner in case it continues to be an owner or it parted from the co-ownership respectively. In order to suffice this, a receiver may also be appointed wherever the court thinks it fit to do so, which will take care of the equal distribution or equitable distribution of the employment or earnings of the vessel. There are situations where majority of the co-owners want to put the vessel on a certain adventure to which the minority of the co-owners are not agreeing to. So, if let us say there are 5 owners, 3 of the owners want to send the vessel on a voyage which is from point A to B, and there are other 2 co-owners who wants to send the vessel on the voyage from point C to D. So, there is disagreement. If there is such disagreement, then even if the majority co-owners proceed with their decision, in such scenario the minority co-owners have a remedy under the said provision, wherein they may institute an action of restraint and seek arrest of ship till the majority of the co-owners furnished bail equivalent to the amount of the share of the minority co-owners. So, a certain bail amount will be furnished in order to secure the interest of the minority co-owners, so that because of the decisions of the majority co-owners, the interest of the minority co-owners is not at stake or is not hampered. Another method through which the security of shares of the minority co-owners can be ensured is by obtaining a bond from the majority co-owners. In such a scenario, then the case would not fall in the purview of Admiralty jurisdiction of the court. However, it must be noted that in both the scenarios, the minority co-owners will not be bound to bear the expenses of the voyage and therefore will also not be part of the profits. Further, another claim can be brought before, or another category of claims can be entertained by the High Court under its Admiralty jurisdiction, and that is with respect to mortgage or charge. Section 4 clause 1 subclause C says mortgage or a charge of the same nature on a vessel. So, a claim can be brought before any of the High Court under Admiralty jurisdiction with respect to mortgage or a charge of the same nature on a vessel. Historically, claim with respect to mortgage extended to registered or unregistered and equitable mortgages. So, generally we see, especially if we talk about India, we will see that under Merchant Shipping Act, if there is any mortgage, it has to be registered. If there is unregistered mortgage, then common law remedy may follow. But at the same time, we need to see that common law remedy is an additional remedy which does not get recognized as far as civil law country approach is concerned. But as far as Indian position is concerned, mortgage are to be registered, and we will see that historically claim with respect to mortgage extended to registered or unregistered and equitable mortgages. However, contemporarily the mortgage has to be registered as per the requirement of section 47 clause 2 of the Merchant Shipping Act 1958. It states as follows: mortgages shall be recorded by the registrar in the order in time in which they are produced to him for that purpose, and the registrar shall by memorandum under his hand notify on each mortgage that it has been recorded by him, stating the day and hour of that record. The above mentioned provision, when read with section 10, which is talking about priority of claims, because there may be a number of claims, what claims should be given priority and they should be first settled, concludes that in order to bring a claim pertaining to mortgage, the claim has to be registered with the registrar of ships in the registry book. So, if the party wants to make it a priority claim as far as mortgage or charges pertaining to mortgage is concerned, then it must register the ship as per section 47 of the Merchant Shipping Act. In England, though, we see that if a ship mortgaged is not registered, an equitable claim is still available depending upon the intention of the parties to create mortgage. Such mortgage is known as equitable mortgage. We also see such claims available under common law remedy system in some other laws as well. However, when we look at the Indian position as far as Admiralty law is concerned, a mortgage has to be a registered one. Further, if we consider civil law system, concerned countries do not recognize equitable mortgage, but only registered mortgage, wherein all the necessary requirements have to be complied with. In case of failure to do so, shall divide the claimant of any claim related to mortgage. Forget about priority of claim. It must also be noted that a claim for mortgage always ranks below the claim of maritime lien. Therefore, a charge in the nature of maritime lien shall be preferred over the claim of mortgage as per section 10 of the Admiralty Act. This provision can be traced back to the historical practice of English Admiralty Court and Exchequer Court of Canada. Now, here, though the claim pertaining to mortgage is of priority, however, when there is a claim pertaining to maritime lien. Now, friends, what is the claim pertaining to maritime lien? Maritime lien is a concept which comes from general lien firstly. So, lien is a concept which says that a charge can be created over a particular property, and when that property is to be sold, the proceeds of that particular property or from the proceeds of the property, that charge can be settled. So, a partial or a complete or a particular type of claim can come into being, which can be calculated up to a certain amount. So, if a property, let us say, belongs to a particular person and a property is having the value of 10 lakh rupees, and if a lien is created against the property, we must also note that lien is always created against the property, wherein charge is also created against the property. So, if a charge of, let us say, 5 lakh rupees is created, then by selling the property of 10 lakh rupees, the 5 lakh rupees can be settled in favor of whom the charge has been created as against the property. The same concept gets applicable as far as ships are concerned. A charge can be created if any particular ship performs a wrongful act. Let us say that a ship sails from point A to point B. Then while it sails from this particular point A to B, there are, let us say, pipelines laid down in this region, and let us say the ship anchors in this region without following due process or without, by mistake or through negligent act, and the anchoring of the ship damages the pipeline passing through this particular region. In favor of the owner of the company who owns the pipeline, a charge will be created against the ship that is sailing in that particular part of the water, and wherever the ship will go, the charge will be carried through with the ship, and out of the proceeds of the profit or out of the ship itself, from the property itself, that is ship itself, himself or herself itself, out of the proceeds or from the ship itself, the charge can be settled. Now, this is the concept of maritime lien. The peculiar feature of the maritime lien is that lien travels with the ship, it does not end at one particular point of time. It travels with the ship till the point it is considered to be legally navigable. Unless and until ship is destroyed, the charge does not get destroyed. It only dies with the death of the ship. And when I say death of the ship, and which occurs only when the ship is no more navigable in nature, that it means that it cannot sail, or it is not in a position to sail anymore. Till that point of time, charge continues. So, therefore, maritime lien has a preferential charge. So, this particular preferential charge which falls within the domain of maritime lien can be of different types. One of the example I have already given you. Section 4 clause 1 subclause D talks about loss or damage caused by the operation of a vessel. During 16th and 17th century, the notion of jurisdiction with respect to loss or damage caused by operation of vessel was divergent. Common law courts did not recognize all claims arising out of loss or damage caused by operation of vessel. Now, friends, here the word arising out of is of a little subjectivity. What do we mean by arising out of loss or damage caused by the operation of the vessel? Here we need to see that a little bit of wider interpretation comes into being as far as arising out of loss or damage caused by the operation of the vessel. The operation of the vessel can be of different instances, and whether direct instance or direct operation of vessel will result into loss or damage, and only then it will be considered to be a claim, or indirect operation of vessel or any particular claim arising due to indirect operation of the vessel, or indirect connection between the loss or damage and the operation of the vessel. Can that indirect connection bring claim or allow the claimant to bring a claim against the ship or the person or the owner of the ship? This is little subjective as far as the law is concerned. It recognized only those claims of tortuous matters that occurred on ship. Anything not taking place on the ship will not form part of the jurisdiction of Admiralty courts, was the stand of common law courts. Even though the struggle was mostly in favor of common law courts, Admiralty court in later times managed to enlarge its jurisdiction, and it was no more limited to anything on board ship, but anything caused by a ship. This was formalized after the passing of Admiralty Court Act 1840 and Admiralty Court Act 1861. The Admiralty Act 2017 uses the term caused by operation of vessel instead of using the phrase done by a ship. So, when we say done by the ship, it somewhere down the line shows direct connection, but when we talk about caused by operation of vessel, we will see what is the interpretation, and it says that unlike its predecessor statute or Senior Courts Act 1981, the literal difference between the two phrases is pertinent to note. The phrase caused by signifies a situation where something makes something else to happen. So, a resulting outcome can also be connected with the operation of the vessel. Here it will mean due to the operation of the vessel or because of the operation of the vessel, some loss or damage occurs, a maritime claim arises. In other words, it is the effect of the operation of the vessel that may form a ground for maritime claim under the said provision. Whereas, the phrase done by a ship means that there is a direct effect of the ship because of which loss or damage has occurred. The primary difference between both the phrases is that in cause, an indirect linkage of vessel and the loss or damage can be established to give rise to a maritime claim, whereas in case of done by, a direct linkage of loss or damage by a ship has to be established. So, therefore, a wider understanding and interpretation has been incorporated by using the term caused by operation of vessel, and therefore, the Indian Admiralty law in this respect can be considered to be broader with respect to maritime claims under the tortuous matters. Further, subclause E of section 4 clause 1 talks about the claims to be brought with respect to loss of life or personal injury occurring whether on land or on water in direct connection with the operation of the vessel. So, here we are not using by the caused by the operation of the vessel, rather we are using the phrase in direct connection with the operation of the vessel. So, if a loss of life has to happen or personal injury is to be claimed, then it should be in direct connection with the operation of the vessel. A further loss of life or personal injury would be too far fetched, and therefore, it will come under the domain of non or unforeseeability aspect. Therefore, this provides for a maritime claim in case of death or injury either bodily or materially. If we can also refer to a case called wagon mount case, which is discussed under the law of torts, wherein the argument of forcibility was accepted by the court in especially in wagon mount 2 case. So, we see that in this under this provision also we can see the inference or similarity as far as the incorporation of the phrase direct connection of the operation of the vessel is concerned, and therefore, the prerequisite for the claim is that it must have occurred as a result of operation of vessel. The loss may either take place on land or on water, wherein the only requirement is that the vessel must be the active cause or noxious instrument for such damage. What is the scope of indirect connection with the operation of a vessel? It may be defect in ship, apparel or equipment, or it may be a wrongful act, negligent or default. Therefore, any defect in ship as whole or its apparel or equipment when it is ready to navigate or is navigating, and in order to ensure its navigation or mechanical propulsion can be ascertained as operation of vessel, which if results into loss or damage to life or personal injury may attract the said provision against the ship owner. Wrongful act, neglect or default, for example, ordering men to work in bad weather on the foredeck, injuries due to the improper working of the coal from the bunkers, etc., can be considered to be wrongful act, negligent act or default. Section 4 clause 1 subclause F talks about claims pertaining to loss or damage to or in connection with any goods. For the purposes of Admiralty jurisdiction, the term goods have been defined under section 2 clause D of the Admiralty Act 2017, and it says goods means any property including live animals, containers, pallets or such other articles of transport or packaging or luggage, irrespective of the fact whether such property is carried on or under the deck of a vessel. In the Essershim case, an English case, it was held that the term baggage shall include only the baggage of passengers, because here when we talk about goods, baggages or the luggage also fall within the domain of goods, as the definition itself says, wherein it means that any property including live animals, containers, pallets, which will also include packaging, luggage, irrespective of the fact that whether such property is carried or under the deck of a vessel. So, therefore, when we talk about baggage or luggage, the interpretation of the baggage is only restricted to the passengers, and we see through Essershim English case that the interpretation of the baggage or luggage has not been extended to the baggage or luggage belonging to the crew members, and therefore, it says that when we say that whether a crew member can bring a maritime claim against the ship owner for damage to its luggage, however, there cannot be found any ground upon which the luggage of the passenger and luggage of the crew member can be distinguished. This can be considered to be a criticism as far as this particular interpretation is concerned. So, therefore, under this head, an action in personam can be brought against the ship owner and no maritime lien will be attached for loss or damage to goods carried on board the ship. However, if the loss or damage has occurred due to collision of the ship, then a claim under maritime lien may be instituted, because then the loss or damage shall be arising out of collision and will not be a simple loss or damage. So, for simple loss or damage with respect to goods, baggage, luggage, etc., maritime lien will not come into being, only action in rem can be brought, that is against the owner. But as far as loss of baggage or luggage occurs due to the collision of the ship, then maritime lien can also come into being, that is action in rem can be brought against the ship. Recovery can also be made not only against the person by instituting a suit against the person, but also by instituting a suit against the ship itself. Therefore, the phrase arising out of provides a wider understanding of connected with the vessel. For example, it may cover under this head claims for breach of charter party, demurrage and freight, and for breach of bill of lading. It has been collected from the previous cases that the provision can be deemed to be wide enough to cover certain other kinds of claims also. So, for example, a claim in negligence brought by sub-charterers against the ship owners for costs and expenses incurred as a result of the vessel having loaded so much cargo that she exceeded the permitted arrival draughts at her discharge port. Another kind of claim could be a claim in negligence or deceit for the antedating of bills of lading, or a claim under an agreement for the mooring and unmooring of a vessel, that is the harboring and unharboring of the vessel. A claim against salvors under an agreement for salvage services. A claim by stevedores. A stevedore is a person employed at the dock. A claim for damages for breach of a towage contract. A towage contract is a contract wherein a particular ship tows the primary ship which is in question. So, if there is a towage contract that is for towing a particular ship, then a claim can be brought also. A claim for an indemnity against the ship owners under a towage contract for the loss of a tug. A claim for wrongful detention of goods, or a claim for contribution or indemnity under the Civil Liability Act 1978 arising out of contract for the carriage of goods in a ship. Lastly, a claim for damages for negligent misstatement by the master of sub-voyage charters as to the cargo capacity of the ship. So, what do we mean by the phrase arising out of read with the other phrase, other words that is connected with? With the case law interpretations, we identify some of the claims that can fall within the domain of arising out of and connected with the vessel. There may be other kinds of claims that can be recognized through upcoming case laws as far as claims are concerned. Therefore, it should be noted that the above mentioned claims do not give rise to maritime liens in case the claim is for loss or damage to goods carried on board a ship. However, if the loss is or damage is caused by damage done by the ship, then maritime lien will apply. So, difference in scenarios, different types of circumstances will give rise to different types of claims. The nature of claim will change as the action of ship changes. If it is caused by damage done by the ship, then maritime lien can come into being, but if it is a claim for loss or damage to goods carried on board a ship, then no maritime lien generally has to be brought into picture. Therefore, an action in rem cannot be instituted in case the goods are on ship and damage is caused to those goods. However, an action in rem may be instituted in case the cause of damage to goods is the ship itself. For example, in case of collision, damage to goods caused as a result of collision shall fall under the category, and maritime lien will be applicable and an action in rem can be instituted. Now, generally a collision would take place due to the negligent activity of the master or the captain, or due to some fault that has come into the ship. So, taking all of that particular aspect into account, such difference of action has been recognized. Further, claims such as for breach of use of best endeavor by ship owners to ensure cargo owners provide salvage security before the release of cargo, for not paying for hiring of container under agreement for releasing a container, for not paying insurance premium of the goods carried on the ship, for broker's commission, for demurrage either under a contract of loading a ship in a specified or under CIF contract, for fees of license, for priority berthing, and for arbitration award. No claim can be brought under this head. A separate claim may be instituted for such contracts individually. Such claims shall be instituted always in personam. 4G talks about agreement relating to the carriage of goods or passengers on board a vessel, whether contained in a charter party or otherwise. In section 4 clause H says agreement relating to the use or hire of the vessel, whether contained in a charter party or otherwise. A seaman can bring a claim against the ship owner for unseaworthiness of the ship. This unseaworthiness might have resulted from defect in ship, its apparel or equipment. Maybe a particular ship has not obtained proper certificates as specified under the Merchant Shipping Act. In such scenarios, it may not be seaworthy. Every ship before sailing is required to obtain certificate of seaworthiness, which implies fitness of the ship to sail. This rule is mentioned under Hague-Wisby rules as well, 1968. failure to show such a certificate will be presumed against the ship owner. However, on production of such certificate shall transfer the burden of proof over the claimant. So, we will discuss this certification part and safety and security part in the upcoming modules also in detail as far as Indian shipping law is concerned. In India, Merchant Shipping Act 1960 and rules with respect to registration of Indian ships provide for obtaining a certificate of seaworthiness, and the onus is upon the ship owner. India, though, is not a party to Hague-Visby rules, but is having its own law, that is Indian Carriage of Goods by Sea Act 1925. The Act first of all states that the absolute warranty of seaworthiness is not to be implied in contracts to which rules apply. That is, in the carriage of goods by sea, it shall not be considered implied that the carrier will provide a seaworthy ship. It will be upon the shipper to be sure of such instance pertaining to seaworthiness of the ship. Section 4, clause I, 1I will talk about claims pertaining to salvage services, including, if applicable, special compensation relating to salvage services in respect of a vessel which by itself or its cargo threatens damage to the environment. A salvage service is provided generally to ship in distress, may be due to collision or which may be due to bad weather or any other kind of reason. Once salvage ships largely try to save the original ship, which may be, let us say, an oil tanker which has collided with a rocky structure, has collided with any other ship, or due to any other fault within the ship, if the ship is in distress, the salvage ship will protect the ship, will try to salve the goods also as much as possible. Traditionally, the salvage agreement were one-sided, which were not in favor of the salvers largely. But in modern times, in the last century, we have seen certain updations with respect to salvers have also come into being. The salver or salvage industry has been tried to be protected through salvage conventions. So, we see that in Indian legal position also, that updated position which somehow tries to save the salvage industry has also been incorporated by taking into account the special compensation rule or method in favor of salvers. Therefore, if you look at the understanding of the salvage, salvage has been defined as a service voluntarily rendered in relieving property from an impending peril at sea or other navigable waters by those under no obligation to do so. Under the Admiralty doctrine of salvage, it is commonly understood as receiving reward for voluntary act of assisting vessel in distress. Earlier, when the sea transaction was comparatively lower to the contemporary times, salvage industry was underdeveloped and the returns for participation were substantially low. Under the Salvage Convention 1910, the underlying principle for remuneration of the voluntary act of saving life or property was based upon no cure, no pay, although it never explicitly appeared in the convention. So, this was under the standard form of contract, and the oldest contract that we can identify, the proper old form of contract would be your Lloyd's form of contract, and Lloyd's form provided for no cure, no pay. So, if salvage trial was made and the salvers could not save any goods or property, and whatever exercise they undertook to save, but if there was no outcome to save, then since there was no outcome, since there was no beneficial outcome, the exercise of the salvers would be in vain and they will not get any payment for the exercise that they have undertaken. This was quite disadvantageous, but then it was improved later on. This was primarily derived from Lloyd's form, which were considered to be the standard form of contract. Article 2 in this respect states, every act of assistance or salvage which has had a useful result gives a right to equitable remuneration. No remuneration is due if the services rendered have no beneficial result. In no case shall the sum to be paid exceed the value of the property salved. The problematic part of this provision was that if no beneficial result comes out, then no reward would be given to the salvers. In order to earn reward, they had to salve some property in distress. We may look at some major incidents such as Torrey Canyon, Amoco Cadiz, wherein and some other incidents causing marine pollution and physical damage to marine environment brought attention of the world towards minimization and reduction of marine pollution, and for that salvage industry also had to be developed. Therefore, in the year 1980, Lloyd's open form came up with an enhanced reward. Lloyd's open form is coming from an English market, it started from insurance, it started providing insurance to the ships and then expanded its horizon by creating different types of contracts. So, it acts as a middle body that connects different parts, either the salver or the shipper or the merchants and the shippers or the charters. So, it provides you the legal backing and legal facilitation as far as maritime transaction is concerned in English market. Therefore, it came up with an enhanced reward that provided for safety net. This would come into play if the salvage contractors acted without negligence. However, their attempt could not result into beneficial outcome. It provided for the expenses incurred by them and an increment not exceeding 15% of the expenses incurred. This can be further viewed in International Convention on Salvage as well. The wordings of the provision as mentioned above is a clear compliance of the new regime by including the special compensation wherever applicable in case of prevention of environmental damage. This may also give rise to action in rem in case the salvage expenses are not paid by the owner and maritime lien can be attached as a result. Another claim that can be brought under section 4 is with respect to towage. Dr. Lushington in The Princess Alice described towage service as the employment of one vessel to expedite the voyage of another, where nothing more is required than accelerating her progress. Historically, we have seen that common law court did not have an objection to Admiralty jurisdiction in claims of towage except within the body of county. There is agreement to the claim in matters of towage as it was mostly exercised at the time of salvage. Further, we also have in the Admiralty Act claims can be brought with respect to pilotage. Pilotage refers to the navigation of a vessel. So, if a ship is sailing and it needs certain type of navigation because of the failure of some navigating system, it needs to reach a particular point, another ship can direct or guide that particular main ship or another vessel can guide. So, this guidance will be known as or navigation will be known as by another ship will be known as pilotage. So, therefore, pilotage refers to the navigation of a vessel by visual reference to landmarks or other external cues. It involves using visual observations to determine the position and direction of travel or navigating a vessel through a channel or passage. Sometimes sailors are under duress and such circumstances may lead to demand of exorbitant remuneration in lieu of the service of pilotage. In such situations, court can exercise equitable jurisdiction. It has been found from the 19th century decisions of Admiralty Court in England that such services do not give rise to maritime liens. Further, section 4 clause 1 subclause L will talk about goods, materials, perishable or non-perishable provisions, bunker fuel, equipment including containers, supplied or services rendered to the vessel for its operation, management, preservation or maintenance including any fee payable or leviable. This claim can be brought by a person advancing goods or materials either perishable or non-perishable, equipment and bunker fuel. It differs from the English law in the aspect that the provision also extends to services and allows claim to be brought not only for supply of goods or materials of the above mentioned nature, but also includes services extended to the vessel for its operation, management, preservation or maintenance. The English law simply refers to claim for supply of goods and materials to a ship for operation and maintenance. This depicts extension of Indian position on inclusion of services also, wherein it further extends itself to include any fee payable or leviable while goods or materials are supplied or any services provided. Section 4 subclause M of the clause 1 talks about claims with respect to construction, reconstruction, repair, converting or equipping of the vessel, and section 4 N clause 1 subclause N talks about dues in connection with any port, harbor, canal, dock or light tolls, other tolls, waterway or any charges of similar kind chargeable under any law for the time being in force. Equipping of the vessel should not be confused with the supply of equipment, since in the former category a material or goods that qualify to be equipment is supplied, whereas equipping corresponds to fixing certain parts of the ship. Therefore, if anything is added or removed in order to construct or reconstruct or repair the ship by either converting or equipping the vessel, then we may say that something of permanent nature is added or removed from the ship, whereas in case of supply of material or goods, it is not permanently attached to the ship. A confusion might occur as to the interpretation of providing services while supplying equipment and equipping the vessel. This can be better understood in the words of Justice Wilmer, as he says, "In my judgment, there is an important difference between equip and supply. Supply being a word which is appropriate for use in connection with consumable stores such as fuel oil, whereas equip to my mind connotes something of a more permanent nature than consumable stores. I can well understand that anchors, cables, hawsers, sails, ropes and such things may be said to be part of ship's equipment, and that none the less though they have to be renewed from time to time, but such things such as coal, boiler, water and food, consumable goods seem to be in quite different category. So, claim can be brought, will be brought with respect to equipments or not with respect to supply. Further, subsection O, we have claim by master or member of a crew of a vessel or their heirs and dependents for wages or any sum due to the wages or adjust to be due, which may be recoverable as wages or cost of repatriation or social insurance contribution payable on their behalf, or any amount an employer is under an obligation to pay to a person as an employee. Whether the obligation arose out of a contract of employment or by operation of a vessel for the time being in force, and includes any claim arising under a manning and crew agreement relating to a vessel, notwithstanding anything contained in the provisions of section 150-51 of Merchant Shipping Act. Now, we also have certain sections pertaining to Merchant Shipping Act which describes and gives a meaning to the term wages, which also includes emoluments, and it says that emoluments mean a profit arising from office, employment or labor, that which is received as a compensation for services, and for that particular aspect a claim can be brought under section 4 before the under the Admiralty jurisdiction. Now, further we have section 4P, which talks about disbursements incurred on behalf of vessel or its owners, and then we also have section Q, which talks about claims pertaining to particular average or general average, wherein the explanation to section 4 of Admiralty Act says that the word particular average and general average are to be given same meaning as assigned to them under subsection 1 of section 64 and clause 1 and clause 2 of section 66 of Marine Insurance Act. Section 64 clause 1 talks about a particular average loss is a partial loss of the subject matter insured caused by a peril insured against, and which is not a general average loss. And 66 clause 2 says that there is a general average act where any extraordinary sacrifice or expenditure is voluntarily and reasonably made or incurred in time of peril for the purpose of preserving the property imperiled in the common adventure. We also have other section 4 clause 1 subclause R, wherein claims pertaining to dispute arising of contract for the sale of vessel can be brought before the court, or for insurance premium, or for commission, brokerage or agency fees payable in respect of the vessel, or with respect to damage or threat of damage caused by the vessel to the environment, coastline or related interests. Measures taken to prevent, minimize or remove such damage, compensation for such damage, all of which can be brought as a maritime claim before the court. Then costs or expenses relating to raising, removal, recovery, destruction or the rendering harmless of a vessel which is sunk, wrecked, stranded. So, costs or expenses relating to preservation of an abandoned vessel and maintenance of its crew. So, claims pertaining to all of these things can be brought before the court. So in today's class we have covered the Admiralty Act of 2017 largely, especially focusing our discussion on the different types of claims and their interpretations, and how do they differ from English position also has been undertaken, how wider and how updated is our law as far as Admiralty claims are concerned, what is the probable interpretation that can be taken into account as far as Indian high courts are concerned, as far as Admiralty law is concerned. So, with this I conclude today's class with respect to Admiralty law. See you in the next class. Thank you for your patient listening. Namaskar.